Good afternoon and welcome to this WorkCover webinar titled How These Top 10 Workers' Compensation Cases Can Impact Your Business. My name is John Canadian and I'm a Senior Lawyer at WorkCover Queensland. Now before we start, we'd like to take a moment to acknowledge the impact of coronavirus and how this may affect Queensland employers. We understand that this will be a very difficult time for everyone, no matter how small or large your organisation is. WorkCover is regularly monitoring the progress of coronavirus across the globe and ensuring our preparedness to process and manage claims arising from the virus. We continue to follow the advice and recommendations from Queensland Health. Our team is working hard to update you on the latest news, which can be found on our website, as well as frequently asked questions about the claims process in relation to the coronavirus. If you have employees working from home, please note that as an employer, you are still responsible for health and well-being of your employees. Workplace Health and Safety has more information to assist you. The slide you're seeing on your screen right now has links to news and frequently asked questions, and you can click on these on your screen. You can't click on these on your screen right now, but we will send you a slide pack with the recording from early next week. If you go to our website now, the picture and the slide that you're seeing is readily available on the website. Now, prior to introducing our guest presenters today, I wanted to let you know that on the screen that you are viewing the webinar through, there is a box on the right-hand side of the screen. This is where you can post questions to us throughout the webinar. We will endeavour to answer these questions as we go through or address them at the end of the webinar if time permits. The webinar will run for about an hour and will finish by 2 p.m. The session will be recorded if you need to leave early, and we'll send a copy out to everyone who is registered by early next week. It will also be publicly available on WorkCover website and through WorkCover's YouTube channel. Now I'd like to extend a warm welcome to our guest presenters today, Ms. Belinda Hughes and Ms. Catherine King. Thank you for making time to present today, Belinda and Catherine. Belinda is a director at Hughes and Lewis with more than 12 years experience in workers' compensation and public liability claims. Belinda has also acted for public liability insurers and directly for clients with large excesses. Catherine is a consultant at Hughes and Lewis and has consulted for motor vehicle, public liability and work cover claims for plaintiff firms as well as defendant firms, and more recently she transitioned to defendant lawyer and has spent the past 4 years specialising in workers' compensation defendant matters. Now, I'd just like to hand over to Catherine to commence the webinar.
Good afternoon, and thank you for all tuning in at a rather unusual time in our community. So for the next hour or so, Belle and I will take you through 10 recent decisions determined by the Industrial Relations Court and the State, District and Supreme Courts. We'll allocate around 5 minutes to each case, and in such circumstances, we obviously can't cover all the issues, grounds of appeal and discussion throughout the judgments, but what we aim to do is briefly summarise the facts and then explain the main issue that the judgments turned on in the context of how knowledge of those outcomes can help you better approach the systems of work and safe procedures you implement in your business to hopefully then minimise the impact of workers' compensation claims. The next 4 cases I'll take you through involve disputes at statutory level. So those claims that are made under the no-fault workers' compensation scheme, in which revolve around whether a worker is entitled to be paid workers' compensation by WorkCover or a workers' compensation self-insurer for an injury they sustained at work. To be entitled to statutory benefits, a person must be a worker defined under Section 11 of the Workers' Compensation and Rehabilitation Act, and they must meet the definition of Section 32, that being his or her injury arose out of or in the course of employment, where employment is the significant contributing factor to causing that injury or aggravation. The main issue in the 4 cases before the Industrial Relations Court that I'll discuss all revolve around Section 32, with just slight variations given the different factual circumstances of each matter. Sakaria and Workers' Compensation Regulator is a case which involved a McDonald's worker, Miss Sakaria, who on 1 November 2016 attended her shift at the McDonald's restaurant in Richlands. McDonald's had a policy which was that staff arrived 10 minutes prior to their shift starting. Ms. Zakaria arrives at work in accordance with the policy, and during that 10-minute period before she starts her shift, she climbed a 3-metre ladder inside the storeroom and up onto the roof of the restaurant where she smoked a cigarette. After her cigarette and whilst climbing down the ladder, she fell and broke her right leg. At the time of breaking her leg, she had not started her shift. The issue in this case was whether her broken leg injury arose out of or in the course of her employment, because obviously her shift had not started yet. Ms. Zakaria applied for workers' compensation benefits, and WorkCover Queensland rejected her claim on the basis that her employment was merely the setting of her injury and was not associated with her duties. She appealed WorkCover's rejection of the claim to the Workers' Compensation Regulator and later to the Industrial Relations Commission, which both upheld WorkCover's rejection of the claim. Ms. Zakaria then appealed the decision of the Commission to the Industrial Relations Court. Just to avoid repetition, this is the review and then appeal process available to all workers and all employers. That is, WorkCover or a self-insurer make a decision, a party to that decision disputes it and requests review by the regulator. Again, the unhappy or losing party can dispute the decision and institute proceedings in the Queensland Industrial Relations Commission, and a party can then file an appeal of the Commission's decision to the Industrial Relations Court, being the final port of appeal for a workers' compensation statutory matter. So Ms. Zakaria argued that the Commission's finding to dismiss her claim was wrong on the basis her injury fell within Section 32(1)A or Section 34(1)C of the Workers' Comp Act, namely that her injury arose out of or in the course of her employment, or that her injury was sustained while attending her place of employment. She failed in her argument that her injury fell under Section 32(1)A because it was found her injury was not suffered in the course of her employment because she wasn't performing any duties at the time she broke her leg. The Industrial Relations Court's decision turned on Section 34(1)C. The section provides that if Ms. Zakaria was at work in accordance with the terms of her employment, so she was directed to be there 10 minutes before her shift as part of McDonald's policy, and she sustained injury whilst absent from her place of employment, namely whilst coming down from the roof, and this absence is during an ordinary recess, provided her injury arose out of normal circumstances such as smoking a cigarette, so nothing abnormal or outside what was foreseeable for her to do on her break, then she is entitled to workers' compensation. The two issues under the umbrella of Section 34(1)C were whether the rooftop was the place of employment and whether the 10 minutes before her shift was an ordinary recess. In relation to the place of employment issue, the regulator argued that the rooftop was not within the place of employment because it was not a designated smoking area for staff. Smoking there had not been encouraged. Ms. Zakaria never sought permission to smoke there, and there was a sign on the ladder warning against going onto the rooftop. The ladder was only ever used by staff members accompanied by a manager when cleaning the rooftop. In determining whether the rooftop was Ms. Zakaria's place of employment, President Martin referred to the test set in WorkCover Queensland and Dreeden, which noted that there must be a connection between the land or property and the work duties of the employee. Consequently, the definition must be applied to each case on its own facts, and thus whether there is a connection is relative to the nature of employment. So these are the sorts of things that were considered. So whilst Ms. Zakaria's employment did include cleaning the roof from time to time, this only occurred in circumstances where it was authorised and accompanied by a manager. Both of these matters supported the conclusion that the roof was not within the place of employment at the time she climbed down from the ladder after accessing it for the purposes of smoking a cigarette. With regards to the second consideration under Section 34(1)C, that is whether Ms. Zakaria's injury occurred in an ordinary recess, she did actually succeed in her argument here. This is because President Martin found that whilst Ms. Zakaria was required to attend her place of employment 10 minutes before the commencement of her shift, there was no work for her to do in that period. He determined it was an ordinary consequence of the employer's requirement that employees arrive by a set time before their shift starts, and that there was for each such employee a recess between the times required to arrive at work and the commencement of the work period. This 10-minute period was therefore held to be an ordinary recess under Section 34(1)C, and she was entitled to workers' compensation benefits. The takeaway in this case is that if you direct a worker to be on site at a certain time before their duties are required to be performed, you must give consideration to what they are allowed to do and where around the place of employment they can reasonably go, as the worker may be considered to be on a break or ordinary recess, and as their employer, you are responsible for them during this period. Glass and Workers' Compensation Regulator is the case which involves a female school teacher, Miss Glass, who whilst on a school trip to Vanuatu injured her left shoulder when she dropped into the Blue Lagoon just outside Port Vila from a knotted rope swing. Section 321A was again considered, namely whether Miss Glass's shoulder injury arose out of or in the course of her employment, and if that employment is a significant contributing factor to her injury. In determining this, the Industrial Relations Court also looked at the scope of Section 321A, namely whether the rope swing activity was incidental or related to her employment as a teacher. To provide some further relevant background, Brisbane Catholic Education employed Miss Glass as a teacher for Xavier Catholic College. In the last week of November 2016, she went on the school trip as one of 5 teachers and 27 students. The school and the International Travel and Advisory Panel of Brisbane Catholic Education approved the trip. On the second day of the trip, the original itinerary to go scuba diving had to be changed, and it was decided the group would go to the Blue Lagoon and use the knotted rope. This itinerary change was not approved by the Travel Advisory Panel, and some of the decision turned on this issue. At the lagoon, there was a platform with a knotted rope attached to a tree. Miss Glass climbed onto the platform, took hold of the rope, swung off the platform over the water, let go of the rope and fell into the lagoon. She told the court that she thinks she sustained injury when she dropped into the water and felt something go in her shoulder. Miss Glass contended that her shoulder injury arose out of her employment because she was doing what she was employed to do, that is, using the rope swing to develop right relationships with students and an inter-respect between the teachers and the students. At the very least, she argued that her use of the rope swing was incidental to her work as a teacher on the field trip. The regulator conversely argued that Miss Glass's actions in using the rope swing formed no part of her role as a teacher, and in doing so she was on a frolic of her own, and that her employment only provided a background or setting for her injury in circumstances where her employer had not improved, induced or encouraged her to participate in the rope swing activity. So Miss Glass's claim was rejected and dismissed on appeal to the Industrial Relations Court, and so she again failed and her claim was dismissed. In President Martin's decision, he looks at the degree an activity will be deemed incidental to a worker's employment. There were 4 main reasons why he said the rope swing activity was not incidental to Miss Glass's employment. Oh, here we go. Namely, the rope swing was not an authorised or approved activity for either staff or students. So in his characterisation of what activities were within the employment relationship between Miss Glass and the school, the President factored in which activities were risk assessed and approved by the school and the Travel Advisory Panel. As mentioned at the start, the rope swing activity wasn't assessed or approved because it was not on the itinerary, and within this context was a recreational and not a work activity. The second and third reasons were that Miss Glass voluntarily hopped on the swing and it was not required by her employer to participate. And the fourth reason was that whilst she was engaging in the swing activity, she was unable to perform her supervisory duties as a teacher. In upholding the Commission's decision to dismiss the claim, the Industrial Relations Court concluded that the Commissioner correctly observed the employment must be important or of consequence so far as the injury is concerned, and that there must be some connection between the two things. Here, Miss Glass was not required to use the swing for any reason. It was something she voluntarily decided to do, and therefore nothing arising out of or in the course of her employment duties as a teacher was significant to contributing her or causing her shoulder injury. The takeaway in this case is that what constitutes a work activity is multifactorial and must be determined in context of whether a worker can actually perform the core of their duties, such as supervision, which appears to be the main role for a teacher on a field trip, and whether the activity itself is necessary for the worker to perform when engaging in the activity. Alborough and Workers' Compensation Regulator, this case considers whether a period of inactivity experienced by a worker whilst waiting for surgery to repair a work-related hernia was a significant contributing factor to causing a subsequent back injury and secondary psychological injury. The background in this case is that Mr. Alborough was employed by Woolworths at its BWS store. On 25 July 2014, he sustained a right-sided hernia in the groin region, which he initially said he sustained while stretching up. In later reportings of the mechanism injury, there's reference to him lifting a carton of beer, and later he talks about slipping, which caused his injury. These inconsistencies are relevant to credibility, and I'll touch on that shortly. Woolworths self-insurer accepted Mr. Alborough's statutory claim, and benefits were paid to him whilst he recovered from his hernia injury. He continued working until 14 October and then complained of lower back pain on the 11th of November to his GP whilst awaiting surgery, so in the period of inactivity. The surgery occurred on the 12th of December 2014. On 2 February 2015, he made another claim for compensation, alleging that he suffered a back injury and a secondary psychological injury arising out of the period of inactivity while awaiting hernia surgery and recovering from it. This claim was rejected by the regulator and dismissed by the Commission. The issue for the Industrial Relations Court on Appeal was whether the back pain arose out of or in the course of Mr. Alborough's employment, and whether work was a significant contributing factor, namely whether the back pain was causally related to the inactivity, the consequence of the convalescing period for the hernia injury sustained at work. The court upheld the decision by the Commission to dismiss the claim, so a lot of the relevant discussion is actually from the Commission's judgment. The Commission looked closely at the period of time surrounding the onset of back pain on 11 November 2014 and following the surgery on 12 December, together with Mr. Alborough's past medical history of 3 years of back pain from 2011 to 2013, to determine what the causes were for the back pain, and namely whether work was a significant contributing factor. In determining medical causation, the evidence of Professor Associate Richard Williams, he's a spinal surgeon, was preferred by the Commission because it was based on the latest MRI and CT scans of Mr. Alborough's spine. Dr. Williams said that the symptoms of lower back pain in November 2014 could have occurred by itself without any period of inactivity due to a number of unrelated or external factors that were causing his pain. Namely, he had an increased body mass index, which was about 41, low aerobic capacity, his smoking behaviour and his psychiatric illness. All of those factors predisposed Mr. Alborough to lower back pain. Dr. Williams said that Mr. Alborough's pain is caused by the degenerative process fundamentally. So the Commission found that the degenerative condition was the significant contributing factor to Mr. Alborough's back pain, not the period of inactivity whilst awaiting and recovering from surgery. This finding was the basis of the appeal to the Industrial Relations Court, and on appeal, President Martin found that the Vice President of the Commission properly considered the evidence and made the right decision. Credit was the other big issue in this case. The Commission found Mr. Alborough to be an unreliable witness of poor credit who overestimated or overstated his symptoms. In such circumstances, the Commission relied on the contemporaneous clinical notes to determine the issue of medical causation because it simply couldn't believe the testimony of Mr. Alborough. Some of the issues that indicated Mr. Alborough was of poor credit were that he had a variety of accounts about how the hernia incident occurred at work, so slipping or stretching up. He said that back symptoms commenced in July 2014, which was wholly inconsistent with the clinical records, noting that he only first mentioned back pain 4 months after. And then his wife gave evidence that she was unaware of back pain until around April 2015, so 10 months after Mr. Alborough said it had come on. Mr. Alborough denied he could recall a 3-year history of lower back pain, despite complaining of it up to 1 year before the hernia incident. The Vice President had enormous difficulty in accepting this and concluded Mr. Alborough could not recall his previous low back pain because he did not wish to harm his case. He told the Commission that after surgery, his hernia pain had never gone away, but none of this is noted by his treating surgeon or his GP when he saw them on 23 December 2014, so just 2 weeks after his surgery. Again, the Vice President was incredibly surprised that anyone who would fail to tell both their doctors of severe pain post-surgery, and she did not accept that he was suffering it. To this extent, the takeaway is that where you question a worker's honesty about how the injury was sustained or its severity, that the contemporaneous reporting of the injury and incident are of significance. Because of this, it's important to document the incident, precisely what the worker told you, have the worker sign the incident report or write it themselves to hold them to account. This assists WorkCover greatly in determining claims at both statutory and common law levels. The other takeaway is that there are multiple causes of pain, particularly with back injuries. What extent the pain is work-related is always considered in the context of multiple factors that could be contributing to determine the major factor causing such pain. The last case is, for statutory cases, is Harrison and Workers' Compensation Regulator, and it's a similar case to that of Alborough in that the court had to consider medical causation in its determination of whether employment was a significant contributing factor to the injury. Mr Harrison was employed by Wallace as an order picker-packer at its distribution centre. He claims that whilst he had work, he sustained an injury to his right elbow when lifting an 18-kilogram crate of milk on 25 February 2016. He made two previous WorkCover claims before 25 Feb. The first was on 15 November 2010 when he struck his right elbow on shelving and returned to full duties. The second was on 23 October 2014 when he suffered right epicondylitis. He had an operation for that injury, eased back to full duties, which he then worked until sustaining the injury on 25 February. The injury on 25 February was accepted as a workplace injury, but the issue was whether the injury arose out of or in the course of Mr Harrison's employment on 25 February or prior to that, and whether his work was a significant contributing factor to the cause of injury or whether other external and unrelated factors were. So the issue in this case was medical causation. Mr Harrison's claim for compensation for the 25 February injury was rejected by Wallace as the self-insurer on the basis that the symptoms suffered on 25 February were a continuum of the earlier injury suffered on 23 October 2014 and that they were degenerative in nature. This was the argument of the regulator on appeal. Mr Harrison's argument was that heavy lifting, namely of an 18-kilogram crate of milk at the time of his injury, was a significant contributing factor to him suffering an aggravation of his right epicondylitis. So Section 32(3) of the Workers' Compensation and Rehabilitation Act indicates that an injury includes an aggravation of a prior condition if the aggravation arises out of or in the course of employment and the employment is a significant contributing factor to the aggravation. So it's the same test as that of an injury. On appeal, the Industrial Relations Court upheld the decision of the Commission that the elbow injury on 26 Feb was a continuum of the previous injury to Mr Harrison's right elbow suffered on 22 October 2014, as opposed to an aggravation of this injury because the MRI of his elbow showed post-surgical changes and some mild tendinosis. And whilst the 26 Feb injury did make symptoms worse, this related to an unsuccessful operation outcome from the 2014 injury, which rendered Mr Harrison no longer fit to perform heavy manual labouring duties, and that because of that prior injury, he would continue to suffer pain when performing heavy tasks. The pain that he experienced was not due to an acute injury sustained in February 2015. So here the court concluded that there was obviously at least one other contributing factor, namely the degenerative elbow condition, and that was found to be the major factor to causing his injury, not the work performed on 26 February 2015. The takeaway for business here is that it is important to hire workers who can physically do the role. After October 2014, it was clear the elbow injury, despite a clearance for work, meant the worker was unsuited to heavy lifting as he would experience ongoing pain. If you require workers to perform heavy tasks and they have had a physical injury, you may want to take extra precautions by getting them independently assessed by your own doctor to ensure they are still suited to such duties.
Just before we hand over to Belinda, there's a question from one of the listeners, Catherine, who's interested to know how the rope swing claim is rejected when compared to fly-in and fly-out workers. Wouldn't it be the same that anything that occurs after the employee enters the airport gates and until their return is compensable? Now, the principle of those cases is based on the cases of Hatchman-Ollis and ANI and PVYW. The place and activity test that's given by the courts, would it be that on the basis of the rejection was because the employer didn't condone the activity or authorise the activity in the glass matter?
Yeah, it essentially wasn't in the scope of employment. It wasn't foreseeable to the employer that anybody would get onto a swing. And also she couldn't perform the main duties of her work, which was to supervise the kids because she was, as the court said, off on a frolic of her own.
Thanks very much. Over to you, Belinda.
Thank you. And thank you, Kat. We're now going to move on to common law claims and common law decisions. Can I start by saying a colleague, Damien Hinkley from Cooper Grace Ward Lawyers, recently undertook an analysis of 2019 court matters involving the Workers' Compensation and Rehabilitation Act. And what he found was that there were 41 decisions handed down in the 2019 calendar year, which involved this act. So they were workers' compensation claims run by WorkCover or self-insurers. Of those, 3 were appeals from earlier judgments heard by the Court of Appeal. And in 2 out of 3 of these appeal matters, the court found in favour of the injured worker. And in all 3 of the matters, the Court of Appeal upheld the decisions of the trial judge who heard the matter at first instance. Now, 2 out of 3 of those cases were slips. One was on a grape and the other was for an aged care worker who slipped showering a patient. The third appeal matter was for a mining worker injured when a large rock was dropped onto the tray of the truck he was driving. Now, much of that appeal concerned the calculation of damages and the likelihood he would have returned to the mining industry if not for the incident. In both courts, that is the Supreme Court and the Court of Appeal, they accepted that he would have gone back to mining. There have also been 9 trials run. Now, 6 were in the Supreme Court and 3 were in the District Court. The difference between those matters is the amount of damages that a court is able to award. So the District Court can award damages of between 150 and 750,000, and the Supreme Court can award damages over 750,000. Of these cases, injured workers were successful in 7 of the 9 matters. The 2 exceptions, that is the cases where the finding was for the employer and not for the injured worker, include a claim for Mr. Bergin against Queensland, Cork and Timber Solutions, which we're going to discuss. The other was a claim by Mr. Corbin, a corrective services officer, who sustained a number of injuries, including a head injury, when he was assaulted by a prisoner. Now, as is common for these types of incidents, so assaults, much turned on the prisoner's history and whether it was foreseeable he would attack the officer, and then what additional steps could have reasonably been taken to prevent the incident. The finding was that the incident wasn't foreseeable and that the employer's policies were appropriate. We've tried to pick out cases with common factual scenarios that employers are encountering. They're mostly slips and lifting incidents, as well as other matters we see affecting claims that we're managing, things like language barriers, past medical histories, and where a worker has knowledge that they're not performing the task correctly. So we can look at how the courts are handling these situations. The statistics above seem a little bit doom and gloom for employers, but that's not the case. These claims never progress to trial for just one reason. It could be that a worker's monetary expectations is seen to be too high. It might be because there are a number of yellow flags that call into question the circumstances of the incident or the extent of injury that require a final determination by a judge. It could be that the third party doesn't agree with the claim or sees it differently, or because there is inconsistency in the factual recounting of what happened between the worker and other witnesses. What the cases do tend to show, however, and I think this has always been the case, is that for an employer to be successful at trial, there has to be a very clear reason why the court should not accept the plaintiff's evidence or version of events, or a reason to cast doubt on the worker's credibility so that their version is less likely to be correct. Now, I'm going to run through 5 cases, and then Kat King's going to come back on and talk about our final case. And then we'll quickly look at what you as an employer can do to best manage the impact of claims on your business. Just quickly, before we step into those cases, it's a good time to review the legislative duty on employers and what is needed for an employer to be liable. The test is contained in section 305B of the Workers' Compensation and Rehabilitation Act, which says an employer does not breach a duty owed to a worker unless the risk was foreseeable and the risk was not insignificant, and a reasonable person in the position of the employer would have taken precautions. This then has to be balanced against the likelihood of the incident, the seriousness of the incident, and the costs and other considerations relevant to precautions to avoid the incident. And of course, the ground of negligence then must be the cause of the injury. For the first case we're going to look at, which is Deans and Maryborough Christian Education Foundation, which is one of the Court of Appeal decisions. Now, this case involves Debbie Deans, who was a school teacher in Maryborough. She sought damages for a left knee injury sustained at 9:05 a.m. on the 4th of March 2015 when she walked from a classroom through a foyer area adjacent to classrooms where 5- and 6-year-old children were having fruit break, and she slipped on a grape. Now, fruit break was held at 9 a.m., 5 minutes before she fell, and required students to leave their classroom and obtain fruit from their bags, which were stored in bag racks in the foyer area where Miss Deans was walking. She was not successful at first instance or on appeal, but the reasons differed slightly. I thought the trial judge, who was Judge Farr's analysis in the district court decision, was helpful in explaining the duty of care owed by an employer. He looked at foreseeability and not insignificant and the reasonableness of alternatives, and he said for the foreseeability test, it was defined as the risk of slipping on a piece of fruit whilst walking through the foyer whilst fruit break was occurring. To prove foreseeability, Ms. Deans relied on the notoriety of young children dropping fruit and children not being properly supervised so that if they dropped fruit, they were not told to pick it up and the teacher didn't pick it up. But His Honour took issue with these allegations, particularly because there was no evidence that in the 5-year period that fruit break had been taking place, that fruit had been dropped and remained on the floor, or that children were inadequately supervised and dropped fruit on the floor and were not told to pick it up. In relation to whether the risk of injury was not insignificant, the trial judge noted that there was no evidence of previous complaints about the way fruit break was conducted or evidence of someone injuring themselves in a similar way, despite the area being traversed thousands of times over fruit break. So he formed the view that the probability of risk was low and insignificant. Ms. Dean's lawyers raised lots of precautions they said could have or should have been taken, including that the school should have changed the floor coverings to carpet. Now, this later happened, but that wasn't due to slipperiness, it was due to the age and appearance of the floor coverings. Also requiring students to partake in fruit break in a different area of the school, instructing teachers responsible for fruit break to provide supervision of the foyer area to ensure spillages were quickly cleaned, instructing ground staff to provide supervision and clean-up services while the children were on fruit break, just not taking fruit break and instead eating the fruit at morning tea, or otherwise storing bags in a different area, which was not a high traffic area. The school system was to instruct and remind teachers to ensure all areas needed to be kept clean and ask students to pick up litter or have the teachers pick it up themselves. And the judge found that the system in place was reasonable and enough. He also said that Miss Dean's accident took place when fruit break was still occurring, and a system of cleaning and inspection could not have taken place almost immediately and would not have prevented the incident. The trial judge's decision with respect to liability was appealed, and the Court of Appeal subsequently agreed that with the trial judge and said he came to the right conclusion and dismissed the appeal, but it made a different finding in relation to foreseeability. It said that the test should have been, was it foreseeable a child could drop a grape on the ground and not pick it up, and a person crossing the foyer could tread on it and slip, without reference to wider evidence of whether this had happened before. And the Court of Appeal said that that was foreseeable. However, the Court of Appeal said that the risk was insignificant because of the lack of previous incidents, and that the other alternative steps raised were not reasonable or would not have prevented the incident. The take home is that more often than not, slips like heavy lifting are going to give rise to a foreseeable risk of injury. So in these cases, looking at the likelihood of the incident with reference to the frequency of the task and past incidents, or the reasonableness of available alternatives is imperative to determining liability. All three of those factors are needed: foreseeability, not insignificant, and reasonable alternatives to find liability. The next case is one of RSL Care and Wallace. It's another Court of Appeal decision and another slip incident. Miss Wallace was an aged care worker who slipped while she was showering a patient on the 27th of March 2008, and she injured her ankle. She took only a few days off work, and 2 years later she was taken to hospital and developed DVT. There were issues with both liability and causation. For liability, Miss Wallace said the floors were slippery when wet, and particularly when there was soap and shampoo on them. This was supported by a previous co-worker who gave evidence at the trial. Expert evidence was obtained by both sides, and both expert engineers agreed that the floor did not comply with standards at the time of testing, but this was 5 years after the incident occurred. RSL Care had applied a non-slip product called Armstrong Accolade Safe Plus in 2002 onto the floors, and that should have made the floors compliant. The problem was the cleaning recommendations were not followed, and the court called this inadequate maintenance. It said RSL Care ought to have had in place a system for appropriately maintaining the floors in the en-suites, and it ought to have periodically tested the surface of those floors, which would have revealed the inadequacy of the flooring, which was later discovered by both engineers. There were also issues determining what injuries were associated with the incident. So the ankle, or also the DVT, and the extent of the ankle injury, particularly as Miss Wallace had issues with her weight, and the DVT was likely caused by being inactive. Miss Wallace's evidence is that while she only had a few days off work after the incident, she had significant ongoing problems with her ankle that worsened in the lead up to her attending the hospital. And this evidence was supported by a friend and her sister-in-law, who said they saw her struggle with pain and saw her ankle when it was swollen and hard for her to mobilise. The medical evidence showed that in the 2 years before attending hospital and after the incident, Miss Wallace had attended on her GP on 5 occasions for unrelated matters and not mentioned her ankle. The trial judge found Miss Wallace had been overweight for some time, and the major change that occurred related to immobilisation from the back slab to treat her ankle, and the DVT was therefore a consequence of the incident. Fortunately, the DVT was not seen to prevent Miss Wallace from working. By the time of the hearing, Miss Wallace had all but completed a degree in nursing, and the trial judge held she would not be precluded from working as a nurse, but her injuries could affect her ability to do the heavier aspects of that role. Future economic loss was calculated at $100 per week until retirement, and she ended up being awarded a figure of about $480,000. Now, RSL appealed the trial judge's finding on liability, and Miss Wallace appealed the trial judge's finding on the calculation of future economic loss, but both appeals were dismissed. In terms of liability, the issue was whether the trial judge could find a breach of duty based on a failed slip test relating to the state of the floor 5 years after the accident. The Court of Appeal said that it was open to the trial judge to find breach on the evidence that existed, and this was because at the date of testing, reasonable steps had not been taken by the employer to ensure the floors were slip resistant. The method of cleaning differed from the flooring manufacturer's maintenance tips, and the practice of using acidic cleaners was something the guidelines specifically said would damage the floors. In light of this, and evidence about the slipperiness of the floor from co-workers and Miss Wallace, and the later test results, it was open to the trial judge to find that the employer breached its duty of care. The take home is it doesn't help taking initial action to prevent against a foreseeable risk of injury if the process later falls apart. Whether that's not following the required cleaning regime, or a practice where guards are sometimes not used on machines, or a system where people are trained initially, but that system is not followed on site. Systems must be enforced and followed. Case number 7 is one of Bergin and Queensland Cork and Timber Solutions. Ms. Bergin sought damages for an injury to his, Mr. Bergin, sorry, sought damages for an injury to his right hand and a secondary psychiatric condition sustained on 18 April 2013 as a result of moving flooring from residential premises. Mr. Bergin was given instructions on how to remove the flooring and told to cut it up into small squares and then lever the flooring pieces up. He reported having difficulty doing the task this way, and then he was shown how to do the task correctly and was observed to perform the task correctly, but later reverted back to doing it the way he had been doing it, which involved using a jemmy bar and manually knocking the flooring up from underneath without cutting it into smaller pieces. Now, Mr. Bergin's history is important, and this is one of those cases with a number of yellow flags. Firstly, in November 2006, around 6.5 years prior to the incident, Mr. Bergin had injured his other hand, that is his left hand, at work. It was a tendon laceration which developed into chronic regional pain syndrome and caused him to suffer from depression. He brought a workers' compensation claim in New South Wales for this earlier injury on the basis that it resulted in significant incapacity for work, and he received a large settlement of $475,000. But he'd spent all of that money by 2012. He first attempted to return to work after this earlier incident sometime between 2011 and 2012, when he started running his own business as a floor sander. He worked for approximately 1 month over a 7-month period that the business was operated. He then worked as a bricklayer for 1 week and as a cleaner for 3 months over the next 9 months before starting with this employer. 3 weeks later, he sustained the injury to his right hand and sought damages for it and the associated psychiatric condition. The effect of Mr. Bergin's pre-existing injuries on his ability to work was a yellow flag, particularly as he'd already been compensated for working capacities flowing from the earlier incident. Now, at the time of the incident, Mr. Bergin was still having pain in his other left hand. He did not reveal the extent of his pre-existing left arm injury and the fact that he had largely not worked for 6.5 years to the doctors who examined him. Prior to being employed by the employer, he continued to seek treatment for the left hand injury and his depressive condition. Just one moment. Sorry. For which he was using drugs and alcohol to control his symptoms. And he'd also applied for a disability support pension. Now, the court held there was no doubt that the role of a floor sander was heavy, and the task Mr. Bergin was required to perform involved manual handling activities that were repetitive. And it created a foreseeable risk of injury which was not insignificant. However, the court said in circumstances where Mr. Bergin was provided with instructions and then shown how to do the task, and given the short period of time between receiving the instructions, being shown how to do the task and then sustaining injury, which was around 2 days, nothing further could have been done to prevent the injury. Now, this was particularly so considering the expense and inconvenience of providing a greater degree of training and assistance. The court effectively said what was done was enough, and a reasonable person in the position of that employer would not have taken further action. Now, of interest, the court said that if Mr. Bergin had proved liability, the appropriate award for future economic loss would have been $50,000, given his poor prospects of continuing long-term in manual labour and as a result of his pre-existing medical conditions from the earlier incident. I think that there's really no doubt that the yellow flags in this matter affected Mr. Bergin's credit, and in doing so, the finding with respect to liability. Sometimes there are yellow flags that turn out not to be an issue. An example might be an incident that's not witnessed. That's not unusual and in itself doesn't suggest anything untoward. But the cumulative effect of multiple significant yellow flags will sometimes form the basis for a court not accepting a worker's version of events and end up defeating a claim, as occurred here. The important thing is to remember, if you have concerns about a claim, they should always be raised with work cover at the onset of the claim and also with the panel lawyer. The second last case I'm going to talk about is one of Cosick and G. James safety glass. Mr. Cosick was an assembler who injured his back performing his work duties on the 21st of January 2014 while operating a vacuum lifter that was being used to transfer glass panes from a trolley to the production line. The purpose of the lifter was to mechanically take the weight of the glass plane. Mr. Cosick was continued working for 3 days after the incident, and then a week later he sought medical treatment. He had 5 weeks off work and then continued on suitable duties before his employment was terminated around 20 months later. Now, Mr. Cosick is Serbian. He gave his evidence with the assistance of 2 different interpreters. Throughout the history of the claim, there were issues with the incident being reported differently at different times. This could have been a yellow flag, but the court thought this was due to language difficulties. The court's willingness to overlook some inconsistencies due to language barriers and its acceptance of Mr. Cosick's evidence was determinative in the case. While it was not possible to determine the weight of the particular glass pane he was lifting at the time, it was thought it was somewhere between 50 and 96 kilograms. Now, depending on the evidence accepted, and when reviewed in light of the way Mr. Cosick describes the event, that is, he says he was holding both handles with his arms outstretched and between shoulder and head height, and while moving the lifter laterally across his body instead of normally in front of him in a front and backwards motion at normal height. The experts concluded that there would have been about a 20 kilogram diagonal force involved in moving the piece of glass. The court found that the employer was liable, and it said that there was a foreseeable risk of injury, which was not insignificant in performing the task the way Mr. Cosick did. It also found the employer's system of work was lacking, as it had not contemplated the risk of injury from the way the task had been performed by Mr. Cosick, or being able to produce any evidence of proper training and enforcement of the system of work. Mr. Cosick was 57 at the time of the incident and 62 at the time of judgment. He had migrated to Australia in 2005 when he was aged around 48, and when he arrived he didn't speak any English, but he did some English courses. He had a significant back injury, but there was a dispute between the doctors about how much of this related to the incident and if any of it was pre-existing. The doctors also disagreed about the effect of Mr. Cosick's pre-existing arthritis and other unrelated medical conditions on his ability to continue undertaking manual work, if not for this incident. The court found Mr. Cosick would have continued working with these conditions, and given his educational background, limited English, age and history of only undertaking manual roles in Australia, he was unlikely to obtain further employment. He was awarded a full loss of income until age 68. The biggest takeaway I see from this case is the effect language can have on a damages award, particularly when combined with an inability to continue in a manual role and difficulties with retraining and returning to the workforce. And of course, there is also the potential for language to explain inconsistencies in evidence, as occurred here. The last case I wanted to talk about is a matter involving Miss Welsh and boutique venues. This is a very recent case that was handed down only earlier this month. Miss Welsh was employed as a chef at Cha 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 restaurant. In April 2017, she was retrieving a tray from a combi oven when the hot water in the tray spilled over the side of the tray, burning her forearm. The viewing window of the combi oven was above Miss Welch's head height, and because it was above her head height, she said she was unable to see the contents of the tray. Now, there were a number of trays in the combi oven, with others containing bread, and there was a dispute over whether Miss Welch had put the creme brulee tray, which she subsequently lifted out, into the combi oven. There was also a dispute about the employer's system of work and training provided to Miss Welch, but the court accepted Miss Welch's evidence on a number of the key facts. In particular, that Miss Welch thought the tray she was retrieving contained bread and not the creme brulees, which were sitting in hot water. Her Honour Judge Rosengren found that the risk of harm was that Miss Welch may mistake the creme brulee tray for a bread tray, and in retrieving the creme brulee tray from the combi oven, sustain a burn from hot water spilling over the tray. She said that this was clearly foreseeable and not insignificant. In relation to steps the employer could have taken to avoid the incident, Miss Welch's lawyers argued she was not provided with sufficient instructions or training, and there was a failure in the system of work such that the trays with water should not have been placed in the combi oven. Her employer said Miss Welch was a qualified chef and was authorised and entrusted to organise her own work duties. In response, Judge Rosengren said if she was, she shouldn't have been. A reasonable person in the position of the defendant would have taken steps to train chefs not to use the combi oven when using a tray with hot water in it, and to enforce a system of work that prohibited that practice. There was no finding of contributory negligence because the finding was that there was no instruction or system in place as to which oven should have been used. She said if an employer had a concern with Miss Welch using the combi oven, which is what she said she usually used when cooking the creme brulees, then it had an obligation to raise it with Miss Welch and enforce its system of work. Now, this case is interesting because it's easy to assume that if a worker is suitably qualified, experienced, or senior within an organisation, that they hold sufficient skills to determine a safe way to perform a task. But that's not the case. The duty to provide and enforce a system of work is always with the employer. And for me, that's the take home from this case. But the case is also helpful because we don't often see claims for more conservative injuries progressing to trial to see how the courts would assess damages in these matters. In this manner, Miss Welch's burn injuries were seen to have caused a 2% impairment and were categorised as minor. There was some dispute about whether they caused her any functional limitations at work. And by the time of the trial, she'd moved into a different role and was working in childcare. The court allowed her $25,000 for future economic loss, calculated as a global sum for disadvantage that she could suffer in the future. I'll hand it over to Kat now for our last case.
All right, Dance and Jamaya's Pty Ltd. So this is a case that was held in the Rockhampton Supreme Court before Justice Crowe. Mr Dance was 44 years old at the time of injury and worked as a baker at Top of the Bay Bakery when he sustained a lower back injury, namely an L5-S1 disc prolapse on 1 November 2016 when he lifted a quad bowl, which is a large industrial bowl containing sausage roll mixture weighing approximately 45 kilos. The main issues were liability, Mr Dance's credibility over his alleged non-disclosure of a long-standing prior back condition, and quantum, so what he should be awarded in damages to compensate his injury at common law. With respect to liability, the case turned on whether lifting a 45-kilogram quad bowl independently was safe. The evidence was that when Mr Dance was first employed by Mr Serra, he was put on a shift with another worker who could assist him with lifting the quad bowl. Later, and then at the time of injury, Mr Dance worked the night shift solo and was required to lift the quad bowl on his own. He did so to transfer the quad mix bowl from floor level to stomach height, and as he did that, he felt a pop crack in his back. The only direction Mr Serra gave Mr Dance was not to lift a fiver by himself, which was baker lingo for a bowl containing 5 times the batch of mix, as opposed to the quad bowl, which had 4 times the batch of sausage roll mix. In absence of manual handling training or a risk assessment of the task, the question was whether this direction to not lift a fiver by yourself was sufficient. The defendant employer argued that Mr Dance was a sensible and competent baker who could be relied upon to work independently and alone without the need for supervision, and so he had the experience to gauge that lifting the bowl was unsafe. As Bell mentioned in Welsh, this is not a factor to discharging an employer's duty of care. The burden is on an employer, not on a worker, to take reasonable steps to minimise the risk of injury in the workplace. Of course, the worker has to act reasonably and take care of their own safety, but it doesn't discharge the employer's duty. His Honour quoted from the High Court in McLean and Tedman and said that accident prevention is unquestionably one of the modern responsibilities of an employer. Accordingly, despite Mr Dance's experience, it was not his job to go to his employer and say, the quad bowl is too heavy and it's awkward to lift on my own. Had Mr Serra of the employer risk assessed the task, he would have determined that the foreseeable risk of injury posed by lifting this amount of weight, the matter Mr Dance had to, could have been minimised had there been another worker to assist with the heavy lift, or if he was directed to leave it on the ground and pipe the sausage roll mix from there. It also inadvertently indicated the direction to not lift a fibre by yourself was clearly an inadequate safeguard to preventing injury. His Honour also briefly discussed CCTV footage. Whilst Mr Serra of the employer did not dispute the incident happened, His Honour said that had he any concern at all as to the circumstances of the injury occurring, he would have retained the CCTV footage. The non-retention of the footage showing the accident allows an inference for the court to draw that Mr Serra was satisfied that the incident occurred as reported. This is a reminder that if a worker is injured and the incident is unwitnessed and you contest the truth of the version reported to you or it wasn't reported at all, that when you do learn of the incident, you check if it's captured by CCTV and that you make a copy of the footage before it loops over. This sort of evidence is very helpful to work cover and at common law for any claims where an employer disputes what has happened. In relation to credit, the defendant employer alleged at trial that the plaintiff failed to disclose his prior history of back problems and that such conduct should be found to amount to fraud because he was trying to maximise his claim for damages. His Honour went to great lengths to examine the 38 allegations of conduct that was alleged to have amounted to fraud. So as Bell referred to them, yellow flags that when accumulated can have a significant impact on a case. His Honour found the plaintiff was a credible witness and had not engaged in fraudulent behaviour and was of a stoic and honest character. His Honour factored in the plaintiff's commendable attempts to return to work post-injury, that Mr Serra spoke highly of him, and the evidence of Mr Dance's wife, who gave context to her husband's misunderstandings of the questions asked about his prior back condition, which helped to explain away the appearance of him omitting to or skirting the answers about his prior back condition as a lack of articulation and use of adverbs, namely that he spoke in slang. He wasn't actually trying to lie. Because of these factors, His Honour could give Mr Dance the benefit of the doubt, which he has the discretion to do, and the takeaway is that if an injured worker presents well and is of good character, which was confirmed by the other witnesses, Mr Serra and Mrs Dance, a court is likely to believe them, which is always the risk to the employer if they want to run a credit argument. The takeaway on liability is there is no safe lifting limit in Australia. You must risk assess lifting tasks and the work environment such tasks are performed in to minimise the risks posed by workers lifting and twisting. It is an employer's, not a worker's, obligation to ensure systems and standard work practices are safe and that engaging in them safely is enforced. Now you'll see at the bottom of the screen that some $624,000 was awarded in damages to Mr Dance. $400,000 of this was for future economic loss. In Queensland, the greatest award of damages is usually for loss of future earning capacity. That is, the limitations on a worker's earning capacity as a result of his injuries, which may be productive of financial loss. An injured worker doesn't have to prove they are losing income to be awarded future economic loss. At the time of trial, Mr. Dance is working full-time as a baker for a new employer. He told the court that 6 of the 9 hours he worked each day were performed in pain. The award for future economic loss here essentially factored in those 6 hours a day of pain, and His Honour found that Mr. Dance would not be able to tolerate that pain at all after about 3 years of working full-time. By age 49, so he was 46 at trial, he would have a significantly reduced earning capacity, being a loss of hours calculated at $734 net per week, calculated over 18 years by the formula the court uses, and that's how the $400,000 came to be.
All right, so just to finish up, what can we learn from these cases and what steps can you take to minimise the effect of these claims on your business? Some things that we picked up from the cases and from practice. Firstly, if you have an issue with a claim, if the mechanism of injury doesn't sound right, or if you don't think the injury was sustained at work, sorry, raise it at the start and know your rights. As Kat said, as an employer, you can seek a review and then you can take the matter further. The matters we have looked at show that there are lots of cases where the key facts are in dispute. Identify the yellow flags early on. Chances are more will come out later as the claim progresses from medical evidence and other sources, and some will be valid and some won't be, but all can then be considered in the context of the particular case. Go back to basics. Have the risks been properly considered and noted? Has there been training? Is the system of work being enforced? Is there a better way you could be performing key tasks? Prevention is always better than cure, and ultimately the scheme is better if workers are not injured and claims are not made. Finally, if you are unfortunate enough to have an incident occur at your workplace, go back to basics, prepare an incident report, get the worker to describe what happened, ask witnesses what happened, get contact details for witnesses in case they move on and someone needs to talk to them down the track. Collect any CCTV footage, take photos of the incident sites, particularly those sites that are going to change in the 2 years before lawyers get involved and investigate. Undertake an investigation, what went wrong and why, and put all of those documents and related documents together so they don't go missing. Things like job details and contracts are also important. Now, it's obviously not possible to fully investigate every incident occurring in your workplace, but consider the extent of the investigation required based on the nature and the extent of the injury. Also, your knowledge of the worker and any other gut feelings you have about the likelihood of the matter progressing. You won't always get it right, but hopefully it will put you in the best position possible if a claim is made. Thank you.
Thank you for attending the webinar today, and I hope this has addressed some of the queries you've had in relation to the topics. That's a very good summary for employers that Belinda and Kat have put into their presentation today. Obviously, from our perspective, as your insurer, anything that we can do to help along the way as well will certainly be any assistance we can offer. And don't be afraid to give us a call. I want to extend our thanks to Belinda and Catherine for making time in their busy schedules today to present on these cases. And just a reminder that we will send a copy of slides and the recording to everyone who is registered early next week. Now stay tuned for our next webinar, which will cover off topics apologising to a worker after an injury. Now these are amendments which will come into force in the legislation from the 1st of July 2020, so the 1st of July this year. There's changes to the definition of injury for psychiatric injuries. This amendment is now in force. It was in force from the 30th of October 2019, and when is management action considered reasonable? So that's it for the webinar today. Thank you and goodbye for now.